So the Ninth Circuit en banc panel is once again moving to uphold a California firearm restriction. So let's talk about this. But real quick before we jump to this video, if you think the state of California needs to stop violating our rights to keep and bear arms, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee, and they are also huge Second Amendment supporters. They use a lot of proceeds from various blends to actually donate to 2A organizations like Firearms Policy Coalition and Gun Owners of America. So amazing coffee, amazing company that supports the Second Amendment. If you guys are interested, you can use the link down in the details section. And if you use the code ARMSCHOLAR, you can get 10% off of your order. So like I said in the intro, the Ninth Circuit just took another California firearms case up for en banc review. This case involves Ventura County shutting down gun stores, ammunition stores, gun ranges in 2020 in relation to the whole COOF incident. This case is important to help prevent government agencies in states like California from shutting down gun stores, gun ranges, places that sell firearms and ammunition for periods of time when people actually need them the most, when they need their access to keep and bear arms the most. And this whole case involves whether or not a government agency, counties, cities, the state of California can shut down access to our rights. The case we're going to be talking about in this video is McDougal v. Ventura County and was heard originally by a 3-judge panel in the Ninth Circuit. On review, the 3-judge panel found that this case, McDougal, and another case, Martinez, both demonstrated a violation of Second Amendment rights. These two cases involved various periods of times when counties in Ventura and Los Angeles shut down gun stores and firing ranges. In Ventura, from March 20th to May 7th of 2020, a total of 48 days, the county mandated the closure of gun stores, ammunition shops, firing ranges throughout the entire county. The closure prohibited county residents from leaving their homes to acquire any firearms or ammunition and prevented them from being able to maintain proficiency in the use of their firearms by going to firearms ranges. On top of all of that, the various orders issued by the county made violators subject to criminal sanctions and civil liability if they decided not to adhere to those orders. During this period of time, however, the county allowed businesses like hardware stores, laundromats, bicycle shops, and others to stay open, but they would not allow gun stores and gun ranges to stay open. In the lawsuit against the county of Ventura, the plaintiffs alleged that those who did not possess a firearm or ammunition on March 19th were barred from exercising their fundamental rights protected under the Second Amendment until at least May 7th. Similar claims were made in the Los Angeles County case, but one major difference between the LA case and the McDougal Ventura case is that the LA order closures were for about 11 days versus, like I said, the Ventura County was much longer. And therefore, it appears that the Ninth Circuit did take up for en banc panel review the McDougal Ventura case because that is the one they issued the longer opinion on and then kind of carried that over into the LA County case. But also the McDougal case coming out of Ventura was a little bit more of an egregious violation because it was for a longer period of time. The Ninth Circuit 3-judge panel reviewed both of these closures and used the Ninth Circuit's two-step approach, which it has established when reviewing Second Amendment cases. In this type of analysis, the court first asks if the challenged law affects conduct that is protected under the Second Amendment. If it does, then the court moves to step 2 to determine what level of scrutiny should be applied. In reaching their decision, the Ninth Circuit 3-judge panel stated Heller's exhaustive textual and historical Second Amendment analysis, as well as our court's own case law, revealed that the ability to acquire firearms and ammunition and maintain proficiency in their use at firing ranges falls well within the Second Amendment's historical scope. They go on to state that indeed, a complete ban on the ability to acquire arms and ammunition in the closure of a firing range renders the right to keep and bear arms hardly worth the paper it consumed. On that basis, they found access to purchase firearms, ammunition, and the ability to practice was conduct protected by the Second Amendment. Because the court found that the orders burdened conduct protected by the Second Amendment, which is that first step, they then moved to the second step, which is establishing the appropriate level of scrutiny. The court on review found that the closure orders failed under any level of heightened scrutiny, i.e. they failed both strict scrutiny and intermediate scrutiny. The Ninth Circuit's 3 judges who looked at this case originally also hinted at that the orders closing the gun stores for 48 days would also likely be categorically unconstitutional, but since the orders failed both strict and intermediate scrutiny, they did not need to address the whole categorical approach. The McDougal-Ventura decision by the 3-judge panel then carried over to that Martinez Los Angeles case. There, the same 3 judges of the panel found that even 11 days closure would be a clear violation of the Second Amendment. So their decision in Ventura then carried over to Los Angeles. Now, If you know anything about the Ninth Circuit, you would know that it has been the track record of the Ninth Circuit that anytime there is a Pro-2A decision that is issued by a 3-judge panel, the Ninth Circuit then takes it up en banc, and they take it up by a large review of 11 judges. And 50 times out of 50, they have overruled what the 3-judge panel has done and has actually upheld these various types of firearms restrictions. So 50 times out of 50, they have ruled in favor of the government and their restrictions. In fact, Judge Van Dyke, one of the 3 judges on the panel in this case, McDougal, called his shot, essentially saying that the Ninth Circuit would no doubt take this case up en banc to strike down their ruling. He stated in his concurrence in that case that, "I agree wholeheartedly with the majority opinion, which is not terribly surprising since I wrote it. But I write separately to make 2 additional points. The first is simply to predict what happens next. I am not a prophet, but since this panel just enforced the Second Amendment, and this is the Ninth Circuit, this ruling will almost certainly face an en banc challenge. This prediction follows from the fact that this is always what happens when a 3-judge panel upholds the Second Amendment in this circuit. Our circuit has ruled on dozens of Second Amendment cases, and without fail, has ultimately blessed every gun regulation challenged, so we shouldn't expect anything less here." And Judge Van Dyke was 100% correct. The Ninth Circuit just issued an order taking this case en banc. Their order reads, "Upon the vote of a majority of non-recused active judges, it is ordered that this case be reheard en banc pursuant to Federal Rule of Appellate Procedure 35A and Circuit Rule 35-3. The 3-judge panel opinion is therefore vacated." The Ninth Circuit has also indicated that they will hold oral arguments in this case during the week of June 21st of 2022. So that is the date to look forward to as far as the oral arguments on this specific case. This case is about more than just closing gun stores and firing ranges and places where you can actually purchase things. This is a case ensuring that the government cannot restrict your fundamental rights and your exercise of them, especially during a period of time when you need them the most. I know the last time I talked about this topic, when the 3-judge panel issued their opinion, a lot of people said, well, that does us no good because it's already happened, the government already did it, so what's the big deal? The big deal in this case is preventing the government from ever being able to do this ever again. And right now, the Ninth Circuit en banc panel is signaling that they want to allow the state agencies, counties to be able to do this going forward whenever they want. Whenever there is a so-called crisis, all of a sudden they can restrict your access to firearms, to ammunition, to train, all that stuff. They can restrict your right to keep and bear arms. This case and recent actions taken by en banc panels in the Ninth Circuit also point to a larger issue in our current judicial system. The Ninth Circuit has failed to acknowledge the Second Amendment, and at every opportunity, the Ninth Circuit en banc panel has ruled in favor of the government and government overreach. We have seen this play out in cases like Duncan, Young v. Hawaii, Peruta, and now likely is going to play out in this McDougal case. Recently, the plaintiffs in Duncan filed for a Supreme Court review of the Ninth Circuit en banc panel's ruling upholding California's magazine ban. One of the major arguments in that petition to the Supreme Court on why the Supreme Court needs to hear that case was because the Ninth Circuit has expressly stated that they will not refrain from assuming that the Second Amendment is fully applicable and then finding that it is entirely toothless unless and until the Supreme Court tells the Ninth Circuit that they need to stop. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and I support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algore's rhythm. It adds fuel to his jet and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I cannot thank you enough for everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could have ever thought and could ever do on my own. So thank you guys so much for all of your support. If you don't have a comment in mind, just comment down below. There's comment to fuel the algorithm, and that really does help the channel. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this station is built by armed scholars and station will maintain by armed scholars.